I'm Stephanie Matheny. I am the attorney for the Tennessee Clean Water Network based here in Knoxville. I work statewide on a variety of water cases, Clean Water Act citizen suits, and permit appeals primarily.
Hi, I'm Rivkin. I teach here at the UT College of Law. I teach courses in environmental law, public interest lawyering, education advocacy. A lot of my work with the issues that we're going to be raising today come from other public interest lawyering contexts in addition to environmental public interest litigation. And we hope that those perspectives will help you illuminate some of the issues that you may be facing, and we encourage you as we move along to talk about some of those issues, because there are rare opportunities we know that lawyers have to talk about ethical stuff. So don't hesitate to do that. Don't disclose your client's confidences while you do that.
Everything's hypothetical.
Feel free to do that.
And it would be unethical of me not to acknowledge Ben Reed, who is my legal intern through Dean Rivkin and who prepared the PowerPoint presentation that we're going to share with you today. Interns are very useful. Gary Davis's talk this morning I thought was an excellent introduction to what I'm going to talk about today, which is it's your client's case, not yours, if you're an attorney. And that's a hard thing. That's a hard thing to keep in mind in this arena. So an overview of what we're going to talk about today. We're going to start with allocation of roles. We're going to talk about the challenges of joint representation. This is an issue that comes up a lot in public interest environmental law. Attorney's fees and how that might lead to potential conflicts. Not all of us are willing to be paid in quilts. Contact by lawyers with government officials. This is a really fascinating rule and very murky. Trial publicity. Generally when you're doing public interest environmental law, you're trying to publicize what you're doing. And then a few other minor rules that we'll get to at the end. As Dean said, if you have an example or a question or a comment, please go ahead and jump in. We have a lot of ground to cover. These are available on the jump drives, so hopefully you all have a jump drive. I hope they're available online. In the past they have been, but if anyone wants this, I'm happy to provide it. I'm not going to read everything on the screen. I assume everyone here is capable of reading. But the first thing to keep in mind again is that when you're a lawyer and you have an environmental case, you may have developed that case from the beginning. You may have found all of the facts. You may have done all of the file reviews. You may have even gone out and approached an organization and say, hey, would you like to be my client in this case? But it's still that organization's case. And that's really tough sometimes to keep in mind, because as a lawyer doing most, not all, but most of the work, it really feels like it's yours. But ultimately, it's the client's. And so you need to remember that there is an attorney-client relationship and that all of these ethical rules apply. Just one aside, we're using Tennessee rules, but these are all the model rules and they have the same number. Obviously, we can't show you the rules from every state, but these are the model rules. So generally, the client decides the objectives of the representation. So it's the client that decides what it is you're trying to achieve. But then the lawyer shall consult with the client about the means by which to achieve these objectives. So the lawyer doesn't necessarily have to follow the legal strategies or tactics that the client wants, but the lawyer has to consult. And ultimately, as the comment here says, the client could decide, we don't like your tactics, we're going to find another lawyer. That doesn't happen very often. Most of the time in the public interest environmental law context, the clients are more than happy to have you take care of everything, but you still need to keep in touch with them regularly. And Dean?
Yeah, let me add to that. For those of you who are lawyers and have taken courses in interviewing and counseling, The key here, obviously, in terms of a client's objectives and goals and the means of achieving them, the key is a lot of upfront discussion, right? A lot of upfront discussion, because as we're going to talk about, as issues arise later on, to the extent that they can be anticipated early in a structured, systematic conversation with your client, both in interviewing if that's appropriate or a counseling conversation. A lot of these problems can be anticipated and presumably dealt with. Stephanie just said something also that is really relevant to this practice and a lot of areas of public interest practice that are in subjects of unmet legal needs. And that is, in public interest environmental lawyering, as well as other areas, there are not exactly, as Gary talked about, a wealth of lawyers who are out there for clients to go to, right? So when you're talking about, as Stephanie is going to elaborate, when you're talking about what happens when there is a conflict between the lawyers and the client, when the client is directing the lawyer to do something that the lawyer might feel in terms of strategy is not appropriate, and there may be some kind of irreconcilable difference that comes up. What's the choice for the client when there are not other lawyers, to go to? Because these cases are so dependent on statutory attorney's fees, which are, and have been under great attack, or, as in some of Gary's cases, obviously, for the lawyer to get paid, they're dependent on contingent fees in damage cases. So upfront talk and recognizing that upfront talk can presumably forestall this question of where does the client go if you as the lawyer and the client reach something that's irreconcilable.
Which is a good segue into the question of conflicts. And in the environmental law context, public interest environmental law context, often there'll be multiple plaintiffs, multiple petitioners represented by a group of attorneys. And so you have challenges of joint representation. There are certainly advantages to joint representation. As Dean said, there aren't a lot of attorneys, there's not a lot of resources, it's more efficient to pool your resources. But when you're doing this, there are a couple things to keep in mind. The conflicts rules apply, even in the environmental law setting. And so you need to be very clear, and I think A2 is the most important one here, that your representation of one or more clients will not be materially limited by the lawyer's responsibility to another client, a former client, or a third person, or, and we'll talk about this a little bit later, a personal interest of the lawyer. So you need to think about what all of the potential interests are among the lawyers and all of the parties and make sure at the outset that those can be aligned. I have a particular challenge with this because I'm on staff at the Tennessee Clean Water Network, and I am in cases where I represent TCWN and other clients. So I have to make sure when I'm in that situation to keep in mind that I am representing the other clients equally to TCWN. This type of conflict can be waived. Each effective client must give informed consent confirmed in writing. This goes back to what Dean was saying, talk about it ahead of time. And then what I'm going to be saying, put it in writing. Informed consent requires that each affected client be aware of the relevant circumstances and the material and reasonably foreseeable ways a conflict can have adverse effects. So talk about the potential conflict issue. It's really important to have a conversation. It can be a little bit awkward, but again, it's better to talk about it ahead of time than to find out after the fact that there is a problem. You need to be clear about your equal duty of loyalty to each client And my firm recommendation is that you sign, all the parties, all of the attorneys should sign a joint representation agreement at the outset of the representation. Now, how many of us do this all the time? Yeah, this is something we often get into the flurry of litigation and then a few months later think, oh, maybe we should have a representation agreement. It's good to get it done earlier rather than later. It should be in writing. It should set out the goals of litigation. So all the clients should say, yep, these are the objectives of the litigation. Put it in writing in the representation agreement. You need to address in the agreement the benefits and risks of joint representation. That way you are showing that you did have that conversation with the clients because it's in writing. And you need to clearly set forth the fee and cost arrangements. And this is particularly important. Many of these are contingent fee arrangements. Those have to be in writing anyway. And it's also important that there be no ambiguity on the costs. So you need to be clear at the outset, who's going to pay for the expert, who's going to pay for the filing fees, who's going to pay for the court reporter. Also, if there are multiple attorneys from different organizations, it would be really helpful in this agreement to talk about, to set forth in advance how it is you might deal with a compromise of fees, which sometimes happens in negotiation. So I want to talk about a couple of examples of where you might have a group of clients you think are all on the same page, but then they diverge. One of these would be, say you had a private damages case, you had individual plaintiffs who were complaining about flooding downstream from a wastewater treatment plant. In settlement conversations, you find a solution that would help 70% of your clients. You would get your fees, but 30% of your clients couldn't be helped. What do you do? And this is actually a hypothetical example from my hypothetical past. Before I was a lawyer, actually I was a client in this situation. A number of forest protection groups I worked with in the Seattle area appealed a land exchange. We filed a NEPA appeal. A bunch of non-attorneys filed a NEPA appeal. I hate to look at it now, I'd probably be embarrassed. But we were shocked when the timber company turned around and sued us. And I have to say, most of us are on the plaintiff side of things. It can be a little intimidating when you get served with a summons. And we were very pleased that Earth Justice, came and jointly represented all of the parties, stepped in, defended us, helped us. And that obviously was not a situation where you could work out everything in advance. That was more of an urgent situation. But as it happened, one of the groups that was involved, their sole mission was to block all land exchanges. They hated land exchanges, that was their policy. The other forest groups just wanted to make sure the timber company didn't get the old growth forests. So in settlement negotiations, that became a problem. It got resolved by the one group compromising its position, which they did very reluctantly, but for the sake of the other parties.
Let me add, before Stephanie moves on, there's a under-the-radar dynamic that goes on the issues that we're talking about. Something that doesn't get discussed very much for obvious reasons, and that is, how does the lawyer structure the arrangement, for example, if you're representing a community as opposed to multiple groups? How does the lawyer structure the decision-making relationship with that community or with that organization, right? Where there might be people with conflicting ideas about the case. And it goes back to what we're talking about before. Where does the lawyer, decide that there's too much conflict in the client's setting of the goals and the client's desires with respect to the strategies and the tactics in the litigation? How does that work? And there's very little really out there written about this because, number one, it's very much protected by lawyer-client confidentiality. So the idea that, if anybody is going to write about it, a lawyer after the fact, there's got to be all kinds of sort of consent. But think about how that, works in the context of a nonprofit organization that may have conflict, a community organization that may not be structured like that, or just, a community itself where you're representing a number of individuals who have been harmed by a certain practice. This is really, a very important aspect of the ethical dimension to doing this kind of work, and yet it's very often not, surfaced and discussed very much in the literature or the like. So we wanted to emphasize that for you, and how you do it, maybe we can talk about later when we take questions and think about how that process goes forward.
And one example that comes up in real life is, what do you do if you have environmental organizations for plaintiffs and individuals? I know that Sierra Club actually has a policy that it will not enter litigation with individual named plaintiffs, because their view is that puts one person on the same level as a national organization. And that's right. In terms of being a lawyer, you have an equal duty of loyalty to each client. You have an equal duty of loyalty to the individual and the Sierra Club. So I don't think there are any hard and fast answers here, other than put an agreement in writing ahead of time. But it's just very important to be thoughtful about this before you get too far down the road. Positional conflicts. This can come up sometimes, particularly if you're in the same court or administrative body over and over again as the lawyer. It's okay to take inconsistent positions in different cases, but you don't necessarily look that credible if you're doing that. On the substantive environmental issues, you're probably not likely to be doing that. It's probably more likely to be on lesser issues like procedure, but you need to think about that as you're representing multiple clients. How effective will you be as an advocate in a certain body if you're making a different argument than you've made before? Withdrawal. So this is kind of like the nuclear option. If you represent all the clients and a conflict develops, it is possible that you would have to withdraw, that all of the attorneys would have to withdraw from representing all of the clients. And as the comment says, the lawyer ordinarily must withdraw from the representation unless the lawyer has obtained informed consent. So again, get everything in writing. But even with informed consent, you need to think, if you try to withdraw and represent one client, like say in my situation, I represent TCWN and another client. Those two clients develop a conflict. I would like to continue to represent TCWN. That could be hard. I have to think about whether continuing to represent TCWN would interfere with my ability to comply with my duty of loyalty to the other client. And then just the other comment, 29, ordinarily the lawyer will be forced to withdraw from representing all of the clients. I actually take the approach, my preference in litigation is to sign an agreement where all of the lawyers represent all of the clients. And I know that presents this potential of the nuclear option of everything falling apart. But I do that in part because I want to make sure at the outset we agree we're all in this together, we're going to work things out. If things come up, we're going to work things out, and if they don't get worked out, then we're not going to have any lawyers who can do the case. Other organizations have different points of view on that.
If we're finished with this, before moving on to attorney's fees, I couldn't help but tell you about an ongoing case, environmental based case in the state of Minnesota right now. And Gary talked about smirking. When I read about this case, I smirked. This is a case where the state of Minnesota hired the firm of Covington and Burling from Washington, which evidently had done a good bit of work for the state of Minnesota before in different representations. they hired them to bring a natural resources damage suit against 3M, right? No small player in Minnesota. And the natural resources damage suit was based on contamination from the manufacturing process at 3M over PFCs, perfluorochemicals that were used in 3M's process and that contaminated water supplies over a period of about 50 years, right? Well, what made me smirk about this was that evidently, after a year of Covington representing the state of Minnesota in this case, 3M decided, and millions of documents being exchanged and lots of depositions being taken, 3M decided to move to disqualify Covington. Why? Because Covington had represented 3M over the course of about 20 years before the Food and Drug Administration, making the argument that the PFCs were not harmful, right? So that Covington was, you know, rolling along with this good fee for them. And in fact, the 3M lawyers called this greed-motivated side switching. In other words, Covington got this nice retainer to represent the state of Minnesota in this case, and they were ready to ditch 3M, a former client with whom, you know, they had a lot of familiarity with their processes and with the chemicals that they used in their process, right? So this lawsuit was brought by 3M seeking to disqualify Covington from representing the state of Minnesota. And the case is now, an intermediate appellate court, based on rules relating to withdrawal and former client conflicts, ruled that Covington had to withdraw. The state stuck with Covington, and just last week or the week before, the Minnesota Supreme Court agreed to hear the case that the state brought on cert to the Minnesota Supreme Court, as it says, seeking to overturn the appellate court's decision to disqualify. But it's so rich to see this kind of maneuvering, that's going on in an environmental case that obviously needs to be brought, given what I can tell from the facts here about the contamination. It says the underlying suit brought by the state in December 10 accuses 3M of dumping these perfluorochemicals, which have been linked to tumors in the liver and pancreas in animal studies, as well as prostate cancer, cerebrovascular disease and diabetes in human, into surface water that flows into the Mississippi River, or burying them underground, allowing them to seep into groundwater. I mean, an important case that needs to be brought. Why the state of Minnesota would stick with Covington from the outset, when Covington had this prior experience, knowing that, as Stephanie says, the nuclear option was, a potential here, and Covington would have to withdraw, or 3M would challenge them, and that would delay the case significantly, which it looks as if it's going to happen. Is one of the real, dilemmas in this kind of work. How many of you are ever going to face, this situation where you're going to, represent the state of Tennessee, or you're going to represent 3M, or something like that, was your opponent when you were a struggling young, Gary Davis, private environmental law lawyer, is probably unlikely, but that's how these cases can arise over this issue and this provision.
Can I ask a question? Or make a comment?
Yeah.
In
And this is Mary Maston from Tennessee.
It's her birthday.
Happy birthday.
For 4 years.
Mazel tov.
In the civil context, or in criminal law, but not environmental, but we go to these ethics courses, and you always hear about private firms having conflicts, panels, and so you have this situation all the time of lawyers making an argument on one side and then later the other side, or having represented clients and the firm, puts a wall between the lawyers doing the case and not. Did any of that in the Minnesota case? Was that? It
Wasn't mentioned in that case, and you're getting into an area. Stephanie mentioned positional conflicts, right, where the firm represented a client previously took a position that now is contrary to the current client's case. The whole idea of erecting these Chinese, walls and what have you. I mean, it's I don't think that maybe Stephanie can give you a non-contextual sort of answer to how those decisions need to get made. But let's face it, among this group, we don't have enough lawyers in the firm to worry about how many have formally represented, maybe, but very rarely, I think. But yeah, I mean that's the issue, right?
Axel?
Just a quick question. Is there any sort of limits on time between a lawyer arguing for one client and then arguing for another client against that former client? Is there any kind of, like that, time limit?
It's not so much a time limit as it's based on information, and that there's a whole other rule about that would be complicated to go into right now. But it's more about when you were representing the former client, what confidential information did you get? And with that confidential information, if it's even 10 years later, you probably shouldn't be representing someone directly adverse if it's related to the information you got the first time.
Ben?
It's also within it can all be waived with informed consent. So that's
I mean,
one way you could go about it.
That's right. I mean, the former client could waive it. I don't know why they would.
Right.
But that could happen. So no, there's no time frame exactly. It all, as Stephanie and Ben said, it all depends, right? And how you structure it when you're in a firm is a hard question. There's lots of guidance in the rules and what have you. We're not, unfortunately, drilling that deeply.
So the next subject is attorney's fees. We've already touched on the contingent fee arrangement. You need to put it in writing, signed by the client. It should be in that same joint representation agreement we talked about earlier. Dean and I wanted to talk about potential conflicts that can develop between an attorney and a client in the context of negotiating a settlement. And just briefly, I'll introduce it and then you'll...
Sure.
Okay, so hypothetically, you have a Clean Water Act citizen suit against, I don't know, a coal mining company. And they're thinking, you're asking for injunctive relief, so you want them to install better treatment or do some riparian remediation or comply with stricter limits. You want some penalties or a supplemental environmental project, and of course you as the attorney want to get paid for all the work that you did. The coal company doesn't necessarily care that much how things distribute between those three items. They're looking at bottom line, how does it all add up? And so you're potentially in a position when you're negotiating your fees, it could be taking away from money available for injunctive relief or penalties. So it's something that comes up all the time. Generally, it's worked out pretty fairly, and generally the attorneys get paid. But there is an example Dean would like to tell you about where it didn't work out so well.
There's lots of examples. And this doesn't always, only arise, obviously, in the environmental context, where each of the citizen suit statutes have statutory attorney's fees provisions entitling the prevailing party to their fees. Doesn't matter whether the prevailing party is paying the lawyer to do this case or not, because these statutory fee provisions in the environmental laws and in the civil rights laws are all based on a an understanding that there needs to be incentives for lawyers to take on, in the environmental cases, citizen enforcement, in the civil rights cases, civil rights enforcement, and what have you. The problem arose, and I face this outside the environmental context. The problem arises when the defendant seeks to negotiate simultaneously the merits and the fees at the same time, right? So you're in this litigation, you're coming up to trial, the defendant has, the defendant's law firm has made quite a bit of money in discovery, trial is coming up soon, and all of a sudden you get an offer that, as Brenda and I do work under the Federal Individuals with Disabilities Education Act, all of a sudden you get an offer from the school system attorney, but it could be the company attorney in the environmental context that says, we're going to provide, a really good program for this kid, or in the environmental context, as Stephanie says, we're going to clean up what this mess that we made right now, but to do that, we need you to waive your fees. Your clients, we need to waive your fees. Of course, it's a little hollow to say that the client is the decision maker here. The client is benefiting, presumably, really likes this settlement offer, wants to take it, and yet, you as the lawyer are kind of stuck out there with this sort of exquisite dilemma that defendants can put you in. Well, the U.S. Supreme Court dealt with this issue in 1986 in a case called Evans versus Jeff D. It was not an environmental case, but the dynamics are the same. This was a case that was brought on behalf of people with mental health issues in state hospitals somewhere out west. The case went on for quite some time before trial. As I mentioned before, the state came in with an offer soon before trial that gave the plaintiffs substantially all the relief that they were looking for in terms of the conditions of these facilities and what have you, on the condition that the lawyers waive their attorney's fees, okay? Case went to the U.S. Supreme Court on the argument that the attorney's fees statutes, the statutory attorney's fees statutes, were designed to attract lawyers, and that any type of waiver would undermine Congress's, intention behind these statutes. The Supreme Court, in a divided decision in 1986, said no. The way these statutory attorney's fees provisions work, the poor defendants need to have certainty as to what they're going to be paying. And consequently, they are able to negotiate simultaneously merits and fees, because they got to know how much the total package of the settlement is going to be. And that was the ruling in this case. The Supreme Court went on to commend the lawyers for the plaintiffs for bringing this case, and saying, good job, highest ethical standards, because the lawyer did take the settlement, right? Had to, because the client said that they wanted to do that. Each state, or many states, have ethical opinions, ABA does, concerning this practice of simultaneous negotiation. Some states actually have barred it, because it immediately puts the lawyer into some type of conflict of interest situation. The best advice is you got to deal with this in your retainer agreement. You've got to say up front to the client, look, if we get to this point, which is not inconceivable, you can't waive my fees, right? You can't waive the fees. This gets very tricky and sensitive, and you want to avoid it becoming nasty, right? But that's the only way up front that you can anticipate this kind of conflict. And everybody knows that in general, statutory attorney's fees are under siege, anyway. I mean, there have been so many Supreme Court rulings that have taken chunks out of the viability of the statutory fee provision in environmental law as well as other contexts, that, you know, this is just one other, you know, cut of 1,000 knives to this important incentive.
Question. Dean, I was just going to say, we've run into this several times over the years, and the thing that I was never aware of until several years ago was, you know, you talk about attorney's fees. The fees are their clients. The case law is clear. Under all the environmental statutes and the civil rights statutes, you know, the fees are the client's property.
Even though they didn't pay you.
Right,
fees,
exactly.
right. They're the
Exactly.
client's
So that's
decision.
why I was just going to say, as you talk about, and that's what Gary and I do, we address it in our retainer agreements
Right.
beforehand.
Right.
You know, because we got burned once, and you can't, or, you know, not, I mean, burn might be a strong word, but it hurt. But,
It
you know,
hurts
you
when
do
you-
what's best for the client when you can, but, you just have to address it up front.
Right.
So I think that's a
Maybe
great
we can
point.
come back to this if we have some time and talk about some, what you put in specifics into the agreement.
And I have never been in a situation where a defendant has asked us to waive fees. More typically, it's a negotiation about the amount of the fees. And, you know, my thought on that is always, you know, defense counsel, are you negotiating with your client about how much they're going to pay you? Or are you just billing them and getting paid? And I was in a situation, I was in a case where we got kind of close to a conflict with another client, and we ended up negotiating our fees to half. Now, don't quote me on that to any defense counsel, because it's not something we ever plan to do again. But
And I have no part in that case.
and Jamie had no part in that case. All right, this is one of the most interesting and confusing rules in ethics, and it comes up all of the time in the practice of public interest environmental law. Dean and I will do this together because we're both so interested in it. It's a short rule, so I'm going to read it. I know you can all read it too, but this is Rule 4.2, communication with person represented by counsel. In representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or a court order. This is commonly referred to as the no contact rule. It applies regardless of who initiates the contact. And it says subject of the representation. It's not just litigation. Okay, so we tend to think, well, I do since I'm a litigator, but I tend to think of litigation, but it's not just litigation. Subject of the representation. Obviously, you can talk to someone about, you can talk to a government official about something that has nothing to do with the particular case, and that's okay. You can talk about the weather and your children, or maybe even another permit, but you need to be careful when you're talking about the specific subject of the representation. You need to know that that person's represented by counsel, and sometimes you can get consent. In the government context, though, there's this authorized by law exception is interesting because we have a constitutional right to petition our government for a redress of grievances, right? And when those of us who became lawyers, got admitted to the bar, we didn't, sign our constitutional rights away, or our clients, because of course we're representing our clients when we're talking to government officials. There is an ABA ethics opinion. It's provided on the jump drive. We're not going to go through that opinion today, but I would highly commend you, if you're a lawyer who does this sort of thing, to read that opinion. It is a fine balancing act.
For those of you who don't have the jump drive, it's the ABA's Standing Committee on Ethics and Professional Responsibility, Formal Opinion 97-408, Communication with Government Agency Represented by Counsel, dated August 2nd, 1997. This is still the framework.
And of course, it's not law, and every state differs, so you need to be careful about whatever rules and precedent there is in the state where you practice. But I find the first part of this amusing. So state legislatures explain that it's unfair for an attorney to circumvent opposing counsel and employ superior skills and legal training to take advantage of the opposing party. It's flattering to think that we have superior skills. Sometimes it's true, often it's not. But but basically, the idea is that we all there is a right to be represented by counsel, just as there is a right to petition government. And that's the balancing act that you'll see play out. So the first part of the rule as it applies generally is, well, what's a person? I mean, generally, government's not a person. Government's an organization. And then you're going to be talking to individual people within the organization. Generally, the rule applies to people at higher levels, managerial levels, people who their statements can be imputed to the organization. So if their statement could be a party admission, that's the level you need to be concerned about. You may be able to talk to low-level employees as a lawyer. You may not, though, because it's a little bit vague. But again, so in general, there's the managerial level. How do you know someone's represented by counsel? Well, governments all have attorneys, right? So all government agencies are always represented by counsel, but the interpretation in the ABA opinion is helpful, which is that it says the government must take affirmative steps to refer a specific matter to counsel, and take the subject matter of the dispute must be concretely identified before the agency is represented. So you don't have to think every time I talk to a permit writer at TDEC, they're represented by counsel. There needs to actually have been a referral to an attorney that you know about. It's not should know, it's you actually know. The ABA opinion suggests, though, even when it's a permissible contact, you should identify yourself as a lawyer and who you represent and what you're asking about. Now, most of the time, I don't know. I talk to the same people over and over again. They all know who I am and what I'm after. But it's just a matter of fairness to let them know what you're doing. Let them know that you're a lawyer and have superior skills.
There are a number of aspects, obviously, to this. Stephanie mentions the balance that the ABA opinion talks about in terms of redress of grievances and First Amendment ability to communicate with government, we as agents, of our clients. Brenda McGee and I do a lot of cases involving school systems, and very, very early on, we were told, you are forbidden from talking to anybody in the school system because we, the county attorney's office, we represent, all people in the school system. Practically speaking, though, the problem here is, let's say you do talk to somebody in, TDEC or EPA or wherever, right? And, you're chatting away, and, you learn that, you learn a piece of information that will support, and the question is there, if there's an ongoing case, this is even more treacherous. If it's not ongoing, you're thinking about a case in the future, you're investigating a case, it's a little bit less so. But what happens when the person discloses information to you that, you think is dynamite, right? And the case ultimately rolls on, and you come to a trial of some kind or administrative hearing. What happens then? When you call this person, say, to the witness stand, and you say, didn't you tell me, such and such, right? And he says, or she says, no, I didn't tell you. I didn't tell you that. What happens then? You going to become a witness? Right? No, you're not going to be able to become a witness unless you withdraw from the case, right? So this is, this is an area, where you need to think hard if you're the lawyer about how to do this, when to do this, with whom to do this, what the results are going to be, the consequences of it are going to be, I mean, I have to say, I think it's most prudent to be as conservative as possible here in terms of upfront disclosures, in terms of complying with directives from lawyers who represent that organization or lawyers who represent individuals in this government agency. You know, and the reason for that is you can only get into, you know, a shouting match in court, you know, where the case is diverted about your conduct and what you did, and not about what the case is about. So, you know, this is an important day-to-day kind of question that lawyers in this field are going to face. And Aaron?
Well, outside of the context of litigation and active representation of individuals within government agencies by counsel, I think we've all of us who poke around in agencies and talk to agency employees have had this experience of you get the right person to finally pick up the phone and you have that moment where you're like, do I tell them I'm an attorney? Do I tell them I'm an attorney? How do you handle that situation in your work? Because sometimes you can get information from them that you wouldn't, you have that feeling they'll probably talk to you more if they don't know, if you don't disclose that you're an attorney, right?
Well, again, in my work, pretty much everyone knows who,
Oh, right.
I mean, I talk to the same people over and over again, and they know who I am and that I'm going to appeal whatever permit we're talking about. Honestly, I would tend to err on the side of disclosure. That's safer for the attorney. There is a little bit of a balancing act, though, when you're representing a client, because you have to zealously represent your client. So, you know, you don't want to be overly cautious, although I don't think any state ethics board would ever find that you didn't adequately represent your client just because you disclosed you were a lawyer.
I mean, it's going to be kind of unusual. Hi, I'm Perrin, and you know, I want to know what parts per million or something, you know, your testing has showed. I mean, isn't the person going to say, who the hell are you, right? And the answer has got to be, I'm a what, you know, you've got to disclose. You can't, you know, you can't dissemble. I mean, you could say, I'm a citizen, which is true, but you know, you're beginning to get into, I think, treacherous territory.
Excellent.
How does that apply to a client?
It doesn't apply to clients, it applies to lawyers.
Yeah, because, you know, just an example, I'm fairly well known in TDEC as to who I am and who I am affiliated with. And say you, Stephanie, are representing me in some case before TDEC. You are forbidden essentially from talking to a TDEC official without having their counsel present or whatever. What if I were to go to that same official and try to dig information out of them and then transfer that information back to you as my counsel? How does that ethically work out?
It ethically works out if you do it on your own without direction from me. I can't tell you what to do because I can't assign someone else to do something that I am ethically barred from doing. And so I literally have had conversations with my boss, Renee, or my coworker, Dana, say, you know, you can talk to them, whatever you want to talk about is fine, you know the issues, but I'm not telling you what to do. And that's a conversation I've had more than once. And I see Ann back there. I think I've had that conversation with Ann before. But it puts the lawyers in a really awkward situation. I mean, I've been at TDEC doing a file review. I'm photocopying, and you know, a permit writer comes up and starts chatting to me about a contested case, and I'm like, I can't talk to you. Let's talk about the weather or our children or something. But but non-lawyers, you don't have a problem.
What about the role of a hired investigator?
It applies to lawyers. So
Okay.
the lawyers, if the investigator is working at the direction of the lawyer, they can't do it. If they're working at the direction of the client without the lawyer involved, it would be fine.
The situation actually describes happens a lot. Now, can you actually, for instance, finds out some information, can he give that information to you if you're his lawyer and you can use it?
Yeah,
So there's no problem with that.
that's right.
I mean, there's another variation on all of this that, that relates, and that is if you're contemplating litigation or even if you're in litigation, you know, if you're in litigation, presumably the discovery rules give you the ability to obtain documents and what have you. If you're not, there's the, you know, FOIA, the Freedom of Information, the Open Records Law, that presumably give you the ability to obtain government documents and information and what have you. And, you know, there's been litigation in other states where lawyers in cases that have been filed are use the state open records or FOIA statutes to obtain documents as a way of getting them much more quickly than discovery, either through interrogatories or production of documents or depositions do. I mean, this is, you know, this is part of this whole issue.
But as a lawyer, you still have a right to do a file review, even if it's about a case that you're litigating.
Just in terms of citizens versus lawyers, these lawyers' ethics rules really just apply to lawyers. And they're kind of based on the conversation is that if lawyers who have all this training and supposed expertise put an agency, a non-lawyer, at an unfair advantage, whereas a citizen doesn't. So don't
Because we have superior skills.
As citizens don't get too concerned about it. Excellent, Robin. Please.
So I wanna move along because actually there's important stuff in the ABA opinion I want to make sure we cover. So this slide we already kind of talked about. We have the right to petition government. We have the right to do public records. I will say at TDEC and specifically, and I have seen TDEC both in response to a discovery request. I have seen TDEC say, we don't need to give you anything. You've already looked at our files. I don't think that's quite right. I think that they actually have to look for the emails that they didn't happen to have in the paper file and answer my rogs and do that. The flip side is, I've had a situation where actually my coworker, who is a non-lawyer, asked for a file review on a case we were working on, and I had the attorney call me up and say, hey, if you do that again, please let me know first. Like, okay, I'm willing to do that as a courtesy. I don't have to do that. I don't have to tell you that my non-lawyer is doing a file review. But I will, because I work with you all the time and whatever. The case law, we're running out of time, so I'm not going to go through this. But basically, all of these cases pretty much say, make that distinction between managerial and low level. So that's a pretty big distinction to make. Massachusetts interestingly added this Miranda type warning. So even if it's low level, you know, even if it's authorized, say, hello, I'm Karen, I'm a lawyer with, you know, representing so-and-so about this. ABA opinion. So the ABA opinion, again, if you're a lawyer who does this, read it. Balancing act. So saying it's not entirely open-ended for you to talk to government officials whenever you want to. But, and I will read this, 2 conditions for contacts that would otherwise be prohibited. So we already talked about otherwise, you know, low level wouldn't otherwise be prohibited. Government official to be contacted must have authority to take or recommend action in the controversy. So that kind of means they're higher up, right? And the sole purpose of the communication must be to address a policy issue, including settling a controversy. Now, when I read this, I was shocked. Apparently, I can talk to high-level non-lawyers about settlement of litigation. I don't think I would ever do that. That would just be a little too weird. When you're settling a case, you're usually involving the lawyers. The second part of this, and I think this is pretty important, the lawyer making the contact must afford government counsel reasonable advance notice of an intent to communicate in order to afford an opportunity for the officials to obtain advice of counsel before entertaining the communication. Now, if you were the government lawyer, what would your advice be? Don't talk to the lawyer. So I'm not sure how this rule would play out in practice. One caution on the first part, sole purpose of the communication is addressing a policy issue, not fact-finding. This isn't how you can do discovery.
See, Stephanie, a lot of times I've had the lawyer for the agency refer me to a high-level.
Then you have
person
consent.
Yes,
Yes.
to talk about
All of the,
settlement.
I mean, the basic rule is without consent of the lawyer. If you have consent of the lawyer, that's fine.
So
As
it
a
seems
pra-
to me, number two would be sort of consent with, by notice.
Number two isn't even actually consent.
Well, I mean.
It's actually just saying you tell the lawyer you're going to do it. Now, it's de facto consent because the lawyer is then going to talk to that person. Now, what I do in practice, when, if I'm working on a permit I know we're going to appeal, or if it's already been appealed, I will copy one of the lawyers on an email. I mean, it's simple, it's easy. With TDEC at least, now that Alan Leiserson is gone. With TDEC at least, that usually doesn't mean you don't get the information. You still get to talk to people. You've alerted the government lawyer, but you've also alerted the staff person, hey, you should probably talk to your lawyer first.
One more variation on this real quick, and Gary mentioned it. What happens when somebody inside the agency, whistleblower, calls you, right? I mean, Gary talked about this in the context of pre-litigation. I mean, you didn't even know there was a case until he learned this, but what happens down the line when the lawyer gets a call from somebody inside the agency with information, right? What do you say then, is there a Miranda warning necessary of some kind before you say that? Complicated, very complicated, so.
Again, keep in mind the managerial level versus not for the general rule. And that might be a case where you could say, I mean, if it's a managerial level person who, well, I mean, again, that actually wouldn't be to settle the controversy. That would be for getting information, wouldn't it? So that would be a tougher situation.
That would bring in whistleblower
Protection.
protection,
Yeah.
potentially too.
Potentially, right.
But lots of
I
times
thought
you
so.
might get that information and not have to use that person
Right.
Right.
as, it's just information, and then you develop the issue separately
Right.
from that.
But if it's information that only this person sort of or has access to, then and using it puts that person in jeopardy, and the person doesn't want to be in. I mean, this is where this obviously gets complicated.
We had that come up actually. We did a case where a government employee came to our office and said, hey, you should look at this. This is the file you should ask for. I'm not involved. And this was definitely not a managerial level person. It was a low level person. And I, a couple weeks later called up and said, hey, I'd like to look at such and such file, even though I'd never looked at a solid waste file before in my life. And we did a whole case developed out of it.
Also in Tennessee, you have the public employees, the peer, that Barry Salkin is sort of the head of. And so there is an organization that is, and I've had them, the agency people get upset, staff get upset at agency action, and they go through the public employees and for environmental responsibility, and they handle the sort of protection, but then there's some litigation.
Counterpart at EPA too, right?
If you do a file review and you happen to find lots of documents labeled confidential that they fail to pull out of the file, that really ought not to be confidential anyway, but they're in the file. You copy them, you scan them, you decide maybe they ought to be on a website.
Oh my
What kind of issues do you have there?
Well, Edward.
Moscow Airport.
Oh, that's really a big question, isn't it? I don't know. I kind of feel like if they put it in the file for you to look at, it's their bad.
They're mislabeled.
They're mislabeled. Yeah. I would use it. I mean, unless it were clear, I mean, unless it was like someone's social security number or something that could harm someone, but, well, this
Are
is,
there ethical rules if you get an email from someone with some information that was sent to you clearly by mistake, then you're bound not to use that.
And it has a confidentiality clause on the bottom.
well, we could talk about this topic forever. It's actually 11:15 already. I just want to really quickly go through the trial publicity rule. We'll skip the other ones. When you do public interest environmental law, you have this weird balancing between confidentiality and you're going to issue a press release every time you do something. So keep in mind when you issue the press release, both that it's your client's case, so it should be your clients issuing the press release and the clients featured in the press release. But also if it's in the context of litigation, and it's hard to see where this would necessarily come up in environmental lawyering, but perhaps a jury pool issue, you know, like on the Kingston spill. If there had been a jury on that, you wouldn't want to contaminate the jury pool with lots of publicity. So in that situation, the lawyer shall not make a out-of-court statement that the lawyer knows will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. But you can talk about the claim, the information in the public record. Well, pretty much everything we do is in the public record, so that's a pretty broad covering. So just keep in mind, you know, balancing that interest with your client.
Yeah, I mean, just a related and final sort of issue is that you're not necessarily doing the press release or making the out-of-court comments. There's good rules on that. What happens, you know, there's been a proliferation of public interest journalists and organizations. And, you know, what happens when you're doing a case and you're approached by a journalist who you think is sympathetic and wants to do a story about a case that is ongoing? How much can you share? How much, you know, are you substituting the journalist's story for matters that you're prohibited from doing? It becomes, again, a process where you have to think through at the outset very, very, very carefully. So, thanks everybody. We can talk about all of these issues, I know, all day. We appreciate your coming.